Much. Good morning. How many people has ASIC been able to get into jail in the last 12 months because of corporate crimes in Australia?
We have some stats on that.
Yeah, thanks for the question, Senator Bragg. I haven't got the precise numbers of people that have been imprisoned as a result of ASIC investigations, but I can take you through some of the criminal matters where there have been...
I'm just interested in how many people actually go to jail for serious breaches of the corporate law in Australia.
Several people have gone to jail.
Several. Okay. Why don't you take it on notice if you don't know?
I can take it on notice, but I'm also happy, Senator, to take you through some of the examples of those who have been convicted and
I
gone
just
to
want
jail.
the number, so maybe take it on notice.
Yes, Senator.
Can I ask you about the Australian Super matter you mentioned in your opening statement, Mr Longo?
Of course, Senator.
So how many people were injured as a result of Australian Super's actions?
I think a lot of the information relating to that matter I might ask the Chair Court to give you, possibly Commissioner Simone Constant, as our superannuation focus.
Senator, in relation to the matters that the case ASIC had in court, over about a 10-year period, there were more than 90,000 members of Australian Super who had multiple accounts that should have been merged. So over 90,000 people we were concerned about. That's right.
Okay, and I think in some of your submissions to the court, you had obtained some internal communications.
Yes, indeed.
Talking about I think there's a quote here I've been able to dig up. It benefits the member by stopping the $1.50 charge on their duplicate account, but for us it means less revenue.
Yes.
So does that indicate their internal thinking about how they were treating their members at the time?
Well, I can't speak for Australian Super, but clearly that kind of communication was something that we put before the court in the proceedings, and one of the pieces of evidence that we relied upon. And obviously we're concerned about any action by any superannuation trustee that indicates an intent to benefit a trustee to the detriment of a member. Yes.
Okay, so the fine is the fine is $27 million. Is that right?
Yeah, the penalty that the court imposed was $27 million.
Okay. And is it right for me to say that you being ASIC, submitted to the federal court, quote, the imposition of the pecuniary penalty in the amount of $27 million is not expected to cause a material detriment to members of the fund. It is noted that if the fund had been run at a profit for shareholders and thus contributed to assets owned beneficially by either Australian Super or its shareholders, ASIC would have sought substantially higher penalties.
I haven't got our submissions in front of us.
That's in the judgment. That's
in the judgment? Well, then, yeah, the parties put joint submissions to the court, so I assume that the judgment reflects those submissions.
So you could have sought a penalty of $140 million, but you sought a lower penalty because of the capital base of the fund. Is that right? No,
that's not right.
Okay, well, can you explain it to me then?
Yeah, so when the court imposes penalties, there are a range of factors that the court takes into account, so every case is clearly different. There's a list set out in the legislation, and there's also a lot of court-based law. So the kinds of things that the court will take into account will be the size of the company involved, the nature of the misconduct, the benefit gained by the person who's engaged in the conduct, the vulnerability of the consumers, the involvement of senior management, whether or not the conduct was deliberate. So there is a range of factors, Senator, that go into this. The courts describe penalty as an instinctive synthesis. I must say, in my view, it's an art, not a science, but the benefit to a trustee and the impact on a member is but one of many factors that go into determining penalty.
Okay, so but why did you say that if the fund had been run at a profit for shareholders, ASIC would have sought substantially higher penalties?
I assume that refers to, Senator, is that one of the factors that the court will take into account in determining penalty is any benefit to the wrongdoer. So if the fund does not retain the benefit and it is returned to members, for example, well, then it's a different scenario than if a fund or any other company, for that matter, retains the financial benefit of the wrongdoing and keeps it for its own asset base or gives it to shareholders. So that would be the difference.
Is that your position?
Well,
of ASIC? You would treat the funds in a different way?
No, it's not our position that we will treat funds differently.
So why is that in your submission then?
That submission, Senator, and I haven't got it in front of me, would have been one factor in a range of factors. And as I say, each matter depends on the particular circumstances and the arrangements that sit behind, the particular trustee. So one factor a court will take into account, and ASIC will take into account when thinking about penalties, is who has retained the benefit of the misconduct.
Okay, you're clearly concerned, quite rightly, that if you hit these funds with big fines, like the cases you've got, REST, Australian Super, Cbus, that if they're hit with big fines, that it's the members that will pay.
So
is that what you're concerned about? Because that's what it looks like to me.
Well, we're concerned about a lot of things in the superannuation sector, Senator, as we've talked about on many occasions, and we have an extremely active both enforcement and surveillance program of work, as you're aware of.
I understand that.
We have many cases in court at the moment. All I wanted to take slight exception to, Senator, was your description of sort of ASIC-imposed fines. Just to be clear, these are court-imposed penalties by sitting, an independent judge looking at the facts and imposes the penalties. ASIC makes submissions as to what those penalties should be, and one of the things that we take into account is a benefit to the trustee. Sorry, and just going back to your question about members, and I think this was the subject of some discussion last night.
It was, yeah.
How the trustee pays for its any regulatory penalties, whether they be as a result of ASIC action or any other regulator, is an issue for the trustee, but there is a law, as I understand it, that says that those penalties cannot be paid directly from member funds. Indirectly, which clearly funds have to be paid, and there may be an indirect impact on members as a result of risk reserves being raised.
I understand you have to work with the laws as they are, and my submission would be, I don't need you to comment on this, is that the law has been distorted through the amendments to the trust deeds, and so the reality is that when these big fines come through, the members pay, not the shareholders. Clearly that's been taken into account in this judgment, and my question really to you is, are you going to be consistent with how you deal with this regulatory arbitrage? Because clearly if it was a fund that had shareholders putting capital into the fund, then it seems to me, by reading your submission to the court, that you would have imposed the maximum fine of $140 million. I mean, you're talking about 90,000 people here who've been wronged, and now the members will pay the fine, but the fine would have been bigger if the shareholders had put some money in. Isn't that right?
No, but I'm not sure if I was supposed to respond to that. There's a lot in that question that I would
the question is, I'll give you the question again.
Okay.
Are you going to be consistent with how you deal with this regulatory arbitrage?
ASIC will be consistent with how it deals with its approach to submissions to the court on misconduct by superannuation trustees and any other entity. We are consistent on that. We have a very clear framework. The courts have set out over many decades the factors that are taken into account to send deterrent signals to the market, which is the purpose of civil penalties, and we absolutely take a consistent approach to that, Senator.
Consistent across all funds?
Consistent across all entities, whether they be superannuation funds or any other entity in the market that we regulate. Okay,
so the comment in your submission to the court that notes the status of the fund, how will that apply in a fund that was not owned by unions and employer groups?
Yeah, I really can't answer that without the submissions and the more detail about the situations, and it's a hypothetical situation. We've had many matters against. We've had many matters.
I'll table the materials and we can come back and talk to it later. I don't want you to feel as if you're talking to your submission without knowing what it says, so we can table that and then we can come back to that later.
I think the procedure is you need to provide it to us to do that.
I think there are two elements to that proposition, Senator Bragg. One is, of course, the officer is not operating with the benefit of the material that you're referring to, and that can be resolved by providing it and giving her and her team an opportunity to review it. The second element that I think is more difficult is you are asking her to engage in any case in a hypothetical. That's harder to overcome unless you have a particular case in mind. It's inevitably the case that superannuation funds that are not for profit. Some of these issues are different to superannuation funds, whom the profits are returned to investors. Of course, many of whom are in your support base. Understand that, but there are issues that are going to be very hard for ASIC to respond to unless you've got something actually specific to refer to.
Okay, thank you. So
I just want to follow up on a few things. So thank you very much, Chair. So I think we've now tabled the document in relation to the Australian Super matter.
Yes, I have it, Senator.
There's an extract and maybe also the whole judgment. So can I ask you, in relation to the trustee risk reserve, who funds that?
As I understand it, Senator, it's not my direct area of expertise, but I understand that is the members fund that through fees, and they fund a range of other administrative and other costs of the trustee.
Okay, and then the trustee risk reserve is used for paying regulatory fines, perhaps?
Yes, as I understand it. Again, Senator, I caveat my answer only in that I'm not an expert on how these issues work, but that's my understanding.
Okay, but generally speaking, the members have built up the reserves in the fund through paying higher fees. That is then reserved.
I don't know if they pay. Sorry to interrupt.
For future
Senator.
purposes.
Yeah.
And then in the case of the judgment here, as it says, as you know, in your own hand, Australian Super maintains a trustee risk reserve. And so then...
sorry, Senator. Again, I'm not trying to be argumentative. This is not in my own hand, in ASIC's own hand. This is a judgment of the federal court written by a judge. Now, it will draw heavily on facts agreed between the parties put to the court. I don't demur from that at all, but I just want to be clear. This is an excerpt.
But didn't you agree with the judgment?
Submission or the judgment?
No, I think this is the... I'm so sorry, Senator. We're just trying to ascertain. I've assumed that this is an excerpt from the judgment of the federal court.
yes,
That's right.
it is.
It's
yes.
not. It's not from the joint submissions of the parties.
No, it's the judgment.
Okay.
Yeah,
Okay, and you generally were happy with the judgment?
We were...
These are not trick questions.
What's that?
These are not trick questions.
No, I was just trying to think about... Well, we're certainly... it's an interesting description, Senator, happy with the judgment. We think that the imposition of the penalty amount was appropriate in all the circumstances of this misconduct.
So I'll just take the opportunity to table the document formally that
Thanks,
Senator
Chair.
Bragg is referring to, and also the opening statement as
Thanks,
well.
Chair. So then, I guess just going back to my earlier question around the size of the fine, as I said, it could have been as high as $140 million, and it seems to me, and now you have the paper in front of you, that one of the factors that was taken into account was the status of the capital position of the fund, that it had been funded by members who had created the trustee risk reserve. So is this a factor that you imagine you will take into account when you are in a similar situation in future, for example, in relation to, I don't expect you to make direct comments about these matters, but in relation to REST insurance issues or Cbus issues, that they are of a similar capital status in that the shareholders do not put capital into the fund, the members pay a fee to build up a risk reserve. So do you expect this to be something that ASIC will take into account in future?
the provisions of the legislation require ASIC to take into account the effect of the penalty on members. That's an express provision in the law. So yes, clearly that will be one of many factors that are taken into account in relation to ASIC submissions on penalty to the court. Ultimately, the court will determine that issue, Senator.
Because the higher the fine,
Just going after them.
because the higher the fine, the greater the fine, the more the members pay.
The higher the fine... Well, again, Senator...
The members pay the fines, right? They pay it through the risk reserve.
Yeah. The members don't directly pay the funds. There is the fines, the penalties. The law prohibits that. These penalties can be, as I understand it, sourced from a range of areas, including a risk reserve, including insurance, and there may well be other issues as well, Senator.
Yeah.
So the effect of the penalty on members is one aspect a court will take into account. Against that, Senator, can I just be clear? ASIC has been working very hard to increase penalties across the board in the financial services sector, and this was a significantly high. I think it's the second highest penalty that has been imposed on a superannuation fund. Again, I stand to be corrected on that, but it's a significant penalty, and in our view, it was appropriate in the circumstances.
Okay, you've made your position clear. I won't add any editorial, so thank you for